Good afternoon, everybody. For those of you who don't know me, I'm Philip Nicol-Gent. I'm the Commission's General Counsel. What does that role entail? Well, alongside many GCs around the world, the role of General Counsel today, in addition to providing legal advice, for which I'm supported by a small and professional team at the Commission, it requires an understanding of the wider international developments of regulation and legislation. As the General Counsel of the Commission, that role translates into having an overview of the policy and regulatory developments from the various international standard setters about which the Director General spoke before the break, as well as the European Union and, close to home, the United Kingdom. And whilst the individual supervisory directors have responsibility for liaising with their respective international bodies, my role is to deal with the overlaps and ensure that so far as possible, the Commission, and in turn the bailiwick, are well placed to respond to these. This afternoon, I'm therefore going to speak about some of the international aspects of my role, as opposed principally to the legal, although the two cannot be that easily divorced. Before I do, though, I want to make mention of the Revision of Laws project, about which I hope you're all now aware. There are 4 key aims to the Revision of Laws project. The first of these is to create efficiencies for both industry and the Commission by enhancing the clarity of the legislation and removing inconsistencies which exist as between the various sector laws. Whilst each of these has generally been effective in enabling supervision in the areas in which the law covers, the differences within and between each of the laws in relation to supervisory practices and procedures have resulted in some confusion and inconsistencies, and these have increased over the years as either new laws have been enacted or older laws have been amended. This is, to a certain extent, inevitable, and this is neither the fault of the draftsman nor the Commission. However, by clearing these up, I hope it will make dealing with the Commission more effective, and I also therefore hope more efficient for both industry and the Commission. The second aim is, so far as is possible, to future-proof the bailiwick's regulatory and supervisory regime. The pace of change in the global finance industry is such that the bailiwick needs to be able to respond quickly and appropriately to developments, and to work with the bailiwick's financial services industry as it seeks to extend the range of services on offer and the markets in which it operates. Those of you who have heard me speak before about this project may also have heard me talk of what I describe as the because ofs. By this, I mean those comments which clients or introducers have made to you to the effect that they would love to have brought their business to the bailiwick, but they couldn't because of. Now, I can't stand here on this stage and promise that when you come to me with a because of, I can just change it. It may be there for a very good regulatory reason. Equally, it may be there because no one has actually ever spotted it, or it has not been a problem in the past. If there is a good reason and a case can be made, then the Commission will entertain looking at making appropriate changes as part of the Revision of Laws process, and one of the key audiences that I seek out and that the Commission has been wanting to engage with in this context is actually importantly the business development managers, those who are actually out there and encountering the because ofs. And can I now at this point make a plea for you to pass that message back if your business development colleagues are not with you this afternoon. At this point, I think it's also worth talking about how the bailiwick has legislated to date. It's a key strength of the bailiwick's position in the financial sector that it has flexible regulatory laws. In the initial stages of developing both the Revision of Laws project and the discussion paper that was launched last week, the Commission has engaged in open conversations with a wide number of stakeholders from the financial services sector, and indeed they have emphasised to us time and time again the perceived flexibility of the bailiwick's regime. A number of people have actually suggested that it is a key strength of the legislative framework and the flexibility which allows service providers to be nimble, and that we should tinker with it carefully and indeed at our peril Equally, however, others have suggested that some of those now seeking to bring business to the bailiwick can be put off if there is not a clearly labelled law or set of regulations that specifically cover their activity. They suggest that those considering doing business with the bailiwick in this ever greater world of regulation prefer to see a pigeonhole into which they can place a product or service so as to be able to satisfy those within their own jurisdiction, whether that be lender, investor, their own compliance department, or a fellow regulator. And they would rather see something cast in legislation or rules than rely on an advocate's legal opinion, which, as we know, both costs and is rarely copper-bottomed. There are naturally two sides to this debate, but I want to say here that the Commission is well aware of the great strength that the existing framework provides to the bailiwick and will consider very carefully how and the extent to which it is possible to develop and future-proof the regime in such a way that does not lead to more and greater regulation. Having dealt with the first two aims, I will now move to the third, which is to try and ensure compliance with international standards. As you know, and as we've heard, the IMF last visited the bailiwick in 2010, and its next visit, we understand, is unlikely to be before 2017. Now, standing here in 2014, that seems quite a way off, but I can assure you that in legislative terms, it's pretty much tomorrow. Of course, international standards change all the time, and every jurisdiction will always have drying ink somewhere in its legal library. However, the laws do need to be updated with the changes that have occurred with Basel, IOSCO, and something which I will come back to later in my speech, which is the new standard for the regulation of trust and corporate service providers. The insurance changes, which are more urgent, we have fortunately been able to deal with using a smoother legislative procedure, and they are actually already being enacted as I speak. Finally, in terms of aims, the Commission and industry need to prepare for MiFID II. What is MiFID II? Well, we've heard some discussion of it already this afternoon, and fortunately, it's not for me to stand here and talk about either. That falls to the Investment Supervisory and Policy Division in their presentations tomorrow. But standing here, a word of caution, and I use the analogy, I say, think beer. It reaches parts that other regulations cannot reach, but is somewhat less palatable than Heineken. Which parts of MiFID are going to touch us? As I said, no one can say with any great degree of certainty, as the European Commission is still finalising some of the more technical rules, where often, as we know, the devil lies in these things. What does MiFID present? Well, along with changes, and all changes in regulation, it presents threats, but equally it presents opportunities, and the financial services sector will need to grapple with both of these. Another word, and it's a word to the wise, having recently attended the ISPD town hall, which the Commission ran, there was some confusion around who you were doing business with. And if you're doing business with the UK, and perhaps despite today's by-election in Rochester, you are still doing business with the EU, a point that was perhaps not fully appreciated. Nevertheless, and highly relevant to us all, MiFID II is a very fluid situation, and we will need to possibly consider issuing a further short discussion paper when we know more of it. So, having dealt with the four aims of the revision of laws project, what else do we need to do? Well, one of the key decisions actually is what not to do. As I've said, in terms of legislation, 2017 is tomorrow. So some of the suggestions which we have received through our open house sessions in the last few days will have to be parked, but they won't be forgotten. Some of them are for the Commission, but not all. Some are for commerce and employment, for example, changes and alterations to the companies law or the partnership law, and those will be passed across to them, as we are keen to work in partnership with both government and industry on this. Separately, you will be aware that Gillian Browning, the new Director of Fiduciary, whose role includes innovations and the fintech space, is already working alongside commerce and employment on a parallel process for developing legislation that is fit for the 21st century. The work stream will include reviewing the terms and scope of the Non-Regulated Financial Services Business Law of 2008. To re-emphasise, the Commission currently has on its website the discussion paper, the period for which ends on the 19th of December of this year. As I've said, the timetable is tight, and I'd be very grateful for comments and feedback ahead of that date, and indeed very happy to take that in chunks rather than having it all come in on the 19th. I would rather spend my Boxing Day relaxing than working through this process. So there's a plea from me. If you can get us something ahead, that would be great. The email address is all in the revision of laws discussion paper. Once we have reviewed the feedback, the next stage will be to move to a more formal consultation paper in February of 2015, with the intention of a States report being debated in the autumn of 2015, so that the drafting process can begin with sufficient time to be completed ahead of 2017. Now, as I mentioned, as part of the international standards, one of the drivers is the new and the newest of those standards, which is on the regulation of trust and corporate service providers. A word or two about this. This has been set out by the group of International Finance Centre supervisors, of which I was the chairman of the working party drafting the standard. For those of you who don't know much about the group of International Finance Centre supervisors, or the GIFCS, it is a grouping of many of the international finance centres and includes amongst its members Guernsey, Jersey, the Isle of Man, Gibraltar, Cayman Islands, Bermuda and Macau. In total there are 18 members. The GIFCS is involved principally in the banking and the fiduciary space and has observer status at both the Basel Committee on Banking Supervision and, equally importantly, the Financial Action Task Force on combating money laundering and the financing of terrorism. Representatives attend the FATF plenaries 3 times a year in Paris, where they're able to speak on behalf of the international finance centres and represent us there. It also meets in its own right and alongside the committee meetings of the Basel Secretariat. It was at Tianjin in China in this September that the standard on trust and corporate service providers was signed. It is a fact that will be well appreciated in this hall that little or no regulation of trust and corporate service providers is undertaken in the onshore world. By contrast, however, it is second nature to members of the GIFCS and their jurisdictions, and back in 2011, when I first arrived at the Commission, I was asked by the Commissioners what I thought was a key challenge for the fiduciary sector. My response was the lack of an international standard in the fiduciary space that left it vulnerable when compared with, say, the banking sector with Basel or the investment sector with IOSCO. This, and the timing of this, was against the backdrop of 2008, the falling tax revenues around the world, something that was very firmly being placed at the doors of the IFCs. The timeline here to the development of this standard is important. It makes it clear that the GIFCS took the initiative. In 2011 and then in 2012 when it set up the working party, both of these being somewhat ahead of the 2013 G8 summit at Loch Earn, which began to talk, or was it lecture, about beneficial ownership for the first time. The TCSP standard addresses a number of issues, and whilst I have spoken about it against the backdrop of beneficial ownership, it is important to emphasise that actually it deals with much more than anti-money laundering issues. Part 2 of the standard lays out the 5 key overarching principles that apply to regulators, the regulatory system, and jurisdictions as a whole in relation to the regulation and supervision of TCSPs. These 5 principles speak to an integrated environment where a comprehensive legislative framework, risk-based supervisory practices, cooperation arrangements, and robust enforcement measures promote a sound regulatory supervisory system for TCSPs to operate in. In addition to the principles applying to the regulator, Part 2 of the standard lists the general principles that jurisdictions should implement to create an effective regulatory environment for TCSPs and their clients. And it goes so far as to say this: where jurisdictions do not regulate, for which read, and any number of countries you could name, they are actively encouraged to consider introducing legislation and a regulatory framework in accordance with this standard and promote practices to meet it. This is in a way in which IFCs can show leadership in areas where other countries have not yet trodden. Part 3 of the standard governs the oversight and the operation of licensed TCSPs by the regulator. This part is composed of 10 standards, subdivided onto topics such as licensing, fitness and propriety of controllers and key persons, conduct, financial crime and international standards. It also, though, goes further. It addresses prudential aspects around capitalisation and liquidity. Why are those important? Those are important actually because a properly capitalised and liquid TCSP is able to make proper investment, to train, and to do all those things which allow it to undertake best practice. You may say, well, what's the point of all of that, and why has Guernsey been involved with this, and what good is it for us? Well, it's actually this. None of this is new to Guernsey. This is what has been going on here for the last 10 to 15 years, but it hasn't perhaps been as fully appreciated on the international stage. There has been lots of oblique criticism, but it's making sure that we are recognised for what we have been doing. As I said, most GIFCS members have been doing this. It's an accepted part now of dealing with international finance centres that the fiduciary sector is regulated, and it is recognised by the international community. Indeed, strong contributors to drafting this standard were the World Bank because they recognise the steps that we take. The bailiwick has a good story to tell in the fiduciary sector, and the work of the GIFCS shows both a leadership from a position of strength and allows it to make what is now a mature contribution to the debate on both beneficial ownerships, but also in terms of expressing its credentials as a leading international finance centre. The benefit of the bailiwick having led in the fiduciary space, where others now follow, is that in terms of meeting the international standard of the GIFCS, the changes necessary to the fiduciary's legislation here in this island is in the manner of housekeeping. So the talk which I have heard whisper of, that this is gold plating, actually is somewhat misinformed. From my dealings and meetings with the FATF in Paris, or the US Treasury or the IMF in Washington and others, it is initiatives such as this that allow us to be seen as jurisdictions firmly in the First Division. You'll hear tomorrow from the different presentations from the supervisory divisions of changes in international standards and challenges that these present. As you've heard from the Director General's address today, the number and breadth of international bodies with which we now have to engage has grown. The challenges that that presents for both us as regulator and you as industry are acknowledged, and I hope that through the revision of laws project and other engagements, we can work together in meeting the Commission's mission statement of ensuring confidence in the bailiwick. Thank you very much.